Be seated, court will come to order. It's not quite time to start, you know, just whenever y'all get ready, we'll. Board of Education of Martin County versus Mark Andrew Blackburn. It says the plaintiff.
Ready for the respondent.
Plaintiff ready?
Yes, Your Honor.
Any preliminary matters to take up before we begin testimony, gentlemen?
Yes, Your Honor. Just a couple. You may approach.
Yes.
Yesterday, superintendent, board secretary, board treasurer, and a couple board members were served with subpoenas. We drafted a motion to quash certain items of those subpoenas. I've got a copy of our motion for Your Honor here. We just filed it this morning. Oh, okay. Basically, we'd received subpoenas that requested the parties to provide a voluminous amount of documentation, some of which were unlimited in scope or time. They'd requested any and all communications between the board members and the superintendent, all expenditures of legal fees that the board's paid out since January 1, 2013, any of the legal billing we submitted to the board, a response from the board to the Office of Public Accounts, the number of the current superintendent's sick leave days that he brought with him from Bath County, and all emails between Carolyn Sweeney, our secretary, and Tammy Sloan, our treasurer, with Mr. Meadows. Now, we provided plaintiff's counsel with several documents. We provided them with emails that had to do with Mr. Blackburn directly. We didn't provide any emails that had to do with ancillary or irrelevant matters. We're just asking the court to quash or modify these subpoenas to keep out some of this irrelevant evidence. I mean, obviously, if the subpoena is going to be valid, it's got to request a production of relevant evidence. A lot of the evidence or a lot of the documentation that's requested in these subpoenas isn't relevant to this breach of contract issue. So we're just asking your court to kind of limit or quash certain portions of this subpoena so as only to allow in any pertinent or relevant evidence. And if the court chooses not to quash those subpoenas, then we'd certainly move Your Honor in limine for an order in limine precluding the admission of any such relevant evidence into evidence.
Judge, Mr. Cumbo.
Judge, in brief response, everything that we have asked for is available to any member of the public, but via open records request. So to stand here and argue that we're not entitled to this information simply defies any and all logic. This is information that they would have to produce if you or I made an open records request, and to suggest that we shouldn't have the opportunity to review that information and to determine for ourselves whether or not it is relevant or probative to the issues before the court is simply improper. This is simply an attempt to hide some information that we believe and information that we have that causes us to believe that many of this information is relevant. Now, we will concede in their motion that C and D, relative to the legal fees, is something that we probably should not have in this action, and we will agree to withdraw that part of the subpoena. But these other things are important. Number one, that they're open records, and number two, they may be important to this case. There's information we have and believe there may very well be testimony to the effect that there was a collusion among board members and the current superintendent as to where to place Mr. Blackburn, which is a violation of law. The opposing counsel has argued numerous times when we've been before the court that Mr. Blackburn failed to budget a position for himself, and certainly item B in their list would tell us what we would find in those budgets. There have been other accusations that Mr. Blackburn has failed to do or not do things, and we believe item E is, again, available via an open records request, and we should be able to see what this plaintiff told the Office of Public Accounts relative to Mr. Blackburn's service. The number of sick days for Mr. Meadows, again, Judge, will concede that we don't need that. Again, the emails between Superintendent Meadows and the secretaries, we believe we're entitled to. Again, those would have to be provided via an open records request, and until we see them, we don't know whether or not they may be relevant or probative to this case.
Well, let me ask you a question. Is everything that you have requested listed on your list of exhibits?
Yes, I believe it is, Your Honor.
Yes. You agree with that?
I agree that some of what they've requested is listed on the exhibit list.
Are they all emails? Here's what let me, if I may, we have provided all of the information they asked for. My legal bills, the budgets, the response, everything that's been argued has been provided except one thing, and that is the volumes of emails between board members and each other and board members and the superintendent for things that do not have anything to do with Mr. Blackburn. We have produced all of the emails that have anything to do with Mr. Blackburn from everybody in the office, except these where I'm a party or I've responded and we take the position of privilege. Now, we can give them on a thumb drive, but you can imagine how many emails there would be in a year's period of time. He doesn't say emails involving Mr. Blackburn. It just says all emails from any board member to any other board member or to Mr. Meadows. And I think we've, the question is, these individual board members have had to, run those things off. If somebody wanted that for whatever reason, then it ought to have been asked for prior to a day before the trial, or some were served on Saturday, others were just served Monday or Tuesday. And I don't know how to produce it to where you can sit here and read it all, but we've produced everything that had anything to do with Mr. Blackburn other than what's in this, in which I'm a party to the communications, and we claim privilege.
But it's claim of privilege.
Well, I don't know. Maybe Steve can help me out here. Is that available via an open records request?
If it's communication with the council judge, we're not entitled to that.
That's exactly right. Okay, so what do we have left that's at issue?
I guess all those emails that they just mentioned, Judge. The rest of it they have provided to us.
Now, what emails? Are these all this bulk of emails? How much quantity are we talking about?
It's unspecified because the subpoena just directed our...
I guess a big concern I have is the lateness of this. The day before the trial. That's not really, I'm not...
Well, we got started several days before trial, Judge. As you heard counsel say, some of them were served on Saturday, and then the weather interfered with effective service, and then we had a continuance of the trial, and we had to reboot and start again.
Friday, Saturday, Monday, it's all the same. It's really too close to trial to be bringing in subpoenas like that. I just can't. That's just not a very good practice. Well, I'm going to take the motion under advisement, and we'll take care of each issue as it comes up. Although, quite frankly, I'm not going to delay this thing to spend a lot of time looking at a bunch of emails. That's just not going to happen. I think the issue should be fairly well framed by now, and we need to proceed. Okay.
Judge, there was one other housekeeping issue that we need to clear up while we're on the record before we begin, and that is the subpoena to Craig Priest, who is the board chairman. In conversations with counsel and the court, it's my understanding that there is an agreement that Mr. Priest will be released from his subpoena to appear today, with the provision that he will be made available for a deposition if necessary within 7 days of this trial.
And that's agreeable either way. Correct.
Okay. Anything else?
Judge, I made those are the exhibits we'll be introducing at the trial, and I made a copy for your honor.
Okay, thank you. Appreciate it. Okay, does either side request separation of witnesses?
Yes, I do.
Anyone who's going to testify other than the parties will need to step outside. We have waiting room, witness rooms over here. The bailiff will conduct you to those witness rooms.
Judge, I'm assuming since we're trying our counterclaim, we'll go first. Burden's on us. Thank you, Judge.
Yes, we'd have Mr. Meadows present on behalf of the board, and then they've subpoenaed board members, so You'll have other board members, I guess.
We would assume
Just
Mr.
emphasize
Meadows
that.
is
Sorry?
the representative of the board
Yeah.
here.
Have Mr. Meadows be a representative, everybody else follow the bailiff to the witness room. Witness rooms. Okay. All right, Mr. Wolnitzek, call your first witness.
Judge, we would call Mark Blackburn.
Come around, Mr. Blackburn.
Judge, I'm assuming opening statements aren't needed since you're well familiar with this case.
There's any point in doing that. Mr. Blackburn, raise your right hand. You swear the testimony about to give will be the truth, whole truth, and nothing but the truth, so help you God.
Yes, I do.
State your name, please.
Mark Andrew Blackburn,
And where are you currently employed?
the Martin County School District.
And what is your position with the Martin County School District at this time?
I'm a tenured special education teacher.
And was that your first employment with Martin County Schools?
That was my first employment, yes.
Okay.
Special education teacher.
When did you become employed as superintendent of Martin County Schools?
I became the interim superintendent in February of 2005 and the official superintendent July of 2005.
And did you sign an employment contract in connection with being hired as superintendent?
Yes, I did.
Mr. Blackburn, I've given you a list, a booklet. The court has that, as does Mr. Schmitt, of various exhibits. Would you look at the first exhibit? And what is the first exhibit?
First exhibit is the 2005-2009 superintendent contract.
And on the back page of that, is that your signature?
Yes, it is.
And what is the date of that contract?
Third day of May 2005.
Who else signed that contract?
Dr. Raymond Wells.
And what was Dr. Wells' position at that time?
He was the chairman of the board, the Martin County Board of Education.
And is this document, Exhibit 1, a true and accurate copy of your first superintendent's contract?
Yes, it is.
And was this contract approved by the Martin County Board of Education at a regular meeting?
Yes, it was.
Judge, we would move to introduce Exhibit 1 into evidence.
Any objection? Be introduced as defendant's Exhibit 1. About to get that backwards.
When that contract was entered into at the meeting, was the board attorney present?
Yes, he was.
Who was the board attorney at that time?
John R. Triplett,
And who prepared the contract, Exhibit 1?
legal counsel for the board.
And did this contract include a provision which addressed what would happen if the contract was terminated, not renewed, or not renegotiated?
Yes, it did.
Specifically, what paragraph was that?
Paragraph 14.
And what did that provision provide, if you'd read it to me?
Read it. In the event that the contract is terminated, not renewed, or not renegotiated, Mark Blackburn shall be reassigned to his previous or comparable position at the Martin County Board of Education Central Office.
Was that an important provision?
Yes, it was. Yes, it was. I relied on that position for my future earnings.
At the time you were hired as superintendent, what was your salary?
Roughly $75,000 to estimate.
You were an administrator?
Yes, I was director of personnel.
And what was your initial salary as superintendent?
$88,000.
And was it your understanding that paragraph number 14, just like the other provisions in the contract, would be part and parcel to the agreement between you and the board?
Yes, it was.
And the term of that contract was 4 years?
Correct.
What happened at the end of that contract term?
They awarded me another 4-year contract.
Would you then look at Exhibit 2? Is that your signature on the last page of that document?
Yes, it is.
Is there another signature on that document?
Yes, there is.
And whose signature is that?
Dr. Raymond Wells.
Still the the chairman of the board?
Correct.
What is the date of that contract?
20th day of January 2009.
Is Exhibit 2 a true and accurate copy of your contract with the Martin County Board of Education for the term of July 1, 2009 to June
Yes.
30th, 2013?
Yes, it is.
Contract was approved at the Martin County Board of Education meeting.
Yes.
You were present at the meeting.
Yes.
I'm going to ask you to look at Exhibit 3. What is Exhibit 3?
That is the minutes from the January 2009 board meeting.
And you were present.
Yes.
Did you sign a contract following that meeting?
Yes, I did.
Mr. Wells signed it also.
Correct. Yes, he did.
Judge, at this time I'd move to introduce both Exhibits 2 and Exhibit 3.
Any objection?
No.
Be introduced as Exhibits 2 and 3.
Was board counsel present at that meeting?
Yes.
Who was board counsel?
John R. Triplett.
Who prepared the contract?
John R. Triplett.
Basis of the objection?
The board minutes speak for themselves. The board minutes that they just introduced provide that the contract was submitted by Mr. Blackburn and reviewed by Mr. Blackburn.
Okay, well, I'll let him explain that. That's overruled.
Did you submit the contract to Mr. Triplett?
Not to Mr. Triplett, I submitted it to the board.
And they gave it, well, you don't know what they did with it.
No, I don't know what they did with it.
They had legal counsel though.
They did.
Did you ever talk to Mr. Triplett about the contract?
Yeah, we had conversations, yes.
All right. Did that contract also contain a provision which addressed what would happen if that contract was terminated, not renewed, or not renegotiated?
Yes, it did.
The term number changed, did it not?
Yes,
There were some additional terms
there was.
in this contract.
Yes.
What is paragraph 16, though, the same language as in the prior contract?
That's correct, it was.
Just a new number?
Just a new number.
Did that provision continue to remain important to you?
Yes, it did. I relied on that position, or that provision, for the benefit of my family, and also for my ongoing administrative duties.
There were substantive changes made to that contract, though, compared to the first.
Yes,
correct? But that paragraph didn't change.
that paragraph didn't change, correct,
Other than number.
other than number.
And that was a 4-year contract?
Yes, it was.
What happened at the end of that term?
The board decided not to renew.
So your contract was not renewed, correct?
Correct. Nor did they renegotiate.
Who was hired as the next superintendent?
Steve Meadows.
And who assigned you to the position of tenured classroom teacher?
Steve Meadows.
Did he provide you a letter notifying you of your new assignment?
Yes, he did.
Would you look at Exhibit 4, please?
Yes.
Is that the letter from Mr. Meadows to you reassigning you?
Yes, it is.
What's the date of that letter?
July 2nd, 2013.
We would move to introduce that letter, Your Honor.
Any objection? Be admitted as Defendant's Exhibit 4.
What does this document say about your salary for the year 2013 to 14?
It just says salary is calculated based on the 185 continuing contract, respect to ranking years.
All right. Have you seen a copy of that teacher salary schedule for this year?
Yes,
It's also posted on the website, is it not?
it should be, yes.
Would you look at Exhibit 5 then? What is that?
That is the salary schedule.
Judge, we've moved to introduce Exhibit 5.
Any objection?
No objection.
Be admitted as Defendant's Exhibit 5.
Mr. Blackburn, based upon your education and years of experience, where do you rank on this schedule?
21 years, rank 1, step 1.
You're rank 1?
Step 1.
What is the annual compensation for an administrator at Martin County Schools?
The annual for an administrator,
Yes. Well, let me strike that. What is your salary under Exhibit 5?
$54,493.
Would you then look at Exhibit 6, please?
Yes.
Did you prepare this document?
Yes.
What is this document?
That are my losses compared to a teacher's salary compared to an administrator's salary.
As a teacher, do you receive compensation for extended days?
No, I do not.
Do administrators receive compensation for extended days?
Yes, they do.
What is the amount of compensation for extended days?
They basically take your teacher's salary and divide it by 55 days to get the amount.
And what figure is that this year?
For me, it
Yes, sir.
would have been $16,257.
And that amount is on this document?
Yes, it is.
Do administrators also receive an annual stipend?
Yes, they do.
Do teachers?
No, they do not.
And what is the amount of the annual stipend this year?
$6,648.
Is that document reflected on Exhibit 6?
Yes, it does.
What is the total administrator compensation when factoring in salary, extended days, and annual stipend?
$77,588.
And what is the difference between the total administrator compensation and the total teacher compensation?
$22,905.
And that's shown on Exhibit 6.
Yes, it is.
Have you received your doctorate yet?
Not at this point, no.
Okay. When will you be receiving that?
It should be March 27th.
When you receive that doctorate, what happens under the schedule?
Then another pay increase incurs.
You move to a different
Move to a
rank?
different rank, yes.
Martin County Board of Education make matching contributions to the retirement accounts of their teachers.
Yes,
How about administrators?
yes,
Same percentage?
yes,
What is that percentage?
9%.
And what is the difference between the 9% matching contributions made by the Martin County Board of Education based upon the $22,095 difference in the compensation of an administrator and teacher?
$2,061.
Is that amount reflected on this document,
Yes, it is.
Exhibit 6?
Yes.
When factoring in difference in compensation as well as retirement contributions, what is the total difference in pay between an administrator and teacher at Martin County Schools?
$24,966.
Is that figure reflected on this document?
Yes, it is.
Are the difference between the compensation you currently receive and the compensation you receive once you obtain your doctoral degree reflected on this document?
Yes, it is.
How much is the difference in pay?
$2,555.
And that would be effective in this year,
That'll be effective next school year.
next school year?
Correct.
So for this year, the difference that you're losing is $24,966.
Correct.
Next year would be $30,946.
Correct.
Do you have tenure within the Martin County School District?
Yes, I do.
In fact, Mr. Meadows in his in Exhibit 4 acknowledged that you had tenure, correct?
That is correct.
What does tenure provide to you as a teacher?
Provides a continuing contract for employment.
Mr. Black, what is your intention to retire from the teaching profession?
Once I obtain my 27 years, which will be 2018, 2019.
So how many more years will you be?
6.
And on Exhibit 6, have you figured out the total amount of your loss over the next 6 years between being paid as a teacher and being paid as an administrator?
Yes, I have.
What is that amount?
$179,696.
That amount doesn't include your attorney's fees, does it?
No, it does not.
Does it include any state raises or cost of living increases or any other raises that personnel in the Martin County school system might receive?
No, it does not.
Judge, I'd move to introduce Exhibit 6.
Any objection?
No objection.
Be introduced.
Judge, I believe that is all the questions I have for Mr. Blackburn. Your witness, Mr. Schmitt.
Mr. Blackburn, when did you first obtain a teaching certificate?
It would have been a 1992.
And at that time, did you become employed?
Yes, I did.
And was that here in the Martin County School District?
Yes, it was.
And how long did you work as a teacher in the school district?
For 5 years.
And what did you teach for the first 5 years?
Special education.
And after 5 years, what position did you hold?
Elementary school principal.
And where were you an elementary school principal?
Warfield Elementary School.
How long were you a principal at Warfield Elementary School?
7 years.
And when you were a principal at Warfield Elementary School, did you have extended days?
Yes, I did.
And how many extended days did you have?
I believe it was 30.
So what did that, you have 220, 225
Yeah,
days?
right. 230.
230
Right.
days? Did you have a stipend as principal?
Yes.
And did you receive, was in any way your pay based upon the number of students who were enrolled in your school?
No, it was not.
And what was your pay the last year you were school principal?
I'm not sure. It was probably in the $70,000 range.
Around
Somewhere in
$70,000?
that, probably.
And at some point in time, as I understand it, you you ended up coming to the central office as an administrator.
Correct.
And what year was that?
It would have been 2004, 2005.
Now, a school principal is an administrator, is an administrative position as defined by statute, isn't that
That's correct.
And when did you come to central office? Would it have been in January 2005?
No, it was July of 2004.
July of 2004.
Mm-hmm.
So you were in central office for 1 year prior to becoming superintendent.
That is correct.
And some 6 months or so, 6, 7 months before signing your first contract.
That is correct.
Okay. Now, when you came to central office in July of 2004, what position did you hold?
Director of Personnel.
Was that the only position that you held?
That was-
Administrative position?
That's correct.
So you were sort of Human Resources Director?
Director of Personnel.
And you were in charge of personnel files?
Correct.
Would that be correct? Did you have any other duties, or were your duties restricted to that position?
They were basically restricted to that.
Now, when you went from school principal to central office, how did you get that position? Were you appointed to that position? Did someone transfer you into that position?
Mr. Sloan transferred me into that position.
And Mr. Sloan was who?
The superintendent.
Superintendent Bill Sloan?
Correct.
William Sloan?
Correct.
And he would be the same superintendent who retired effective July 1st, 2005, when you took over that position, correct?
Correct. But he may have retired in January. I'm not really sure.
You may have served as interim
I did serve
for that period of time. So in effect, you were a central office administrator from July 1st, 2004 until January of 2005. When you
Correct.
took over as interim superintendent.
Correct.
Is that correct?
Correct.
And so your central office experience was essentially 6 months.
Not counting the superintendency.
I
Correct.
understand. But it's true, is it not, that a superintendent is not an administrator, it's defined by statute.
That's correct.
Is that correct?
That is correct.
When you became superintendent in July 1st, 2005, what did you do in terms of, if anything, in terms of filling the positions? Did any administrative positions become vacant during the time you were superintendent of Martin County Schools?
Yes, they did.
Okay, and can you tell the court what some of those administrative positions were?
Director of Pupil Personnel, Director of Maintenance, Director of Transportation, Instructional Supervisor. There were several of them.
Okay. And as superintendent of Martin County Schools, did you fill those positions?
Yes, I did.
And you fill those positions pursuant to the authority vested in you as superintendent of Martin County Schools. Isn't that correct?
That is correct.
And the Board of Education didn't fill any of those positions or make any of those appointments, did they?
That's correct.
As a matter of fact, you know, as superintendent, you are the professional advisor to the board. Isn't that correct?
Mm-hmm.
And you're a professional educator who had a superintendent certification.
That's correct.
And what does one have to do to get certification as a superintendent in a Kentucky public school district?
You just go to your college and you receive the degree.
Okay. And how much education do you have to put in to get a superintendent's certification?
Quite a bit.
A year and a half?
Yeah, roughly 2 years.
And during that period of time, you're instructed on personnel matters, isn't that correct?
That's correct.
And you understand that superintendents fill vacancies, and superintendents are responsible for hiring and firing. Isn't that correct?
That's correct.
And you also understand that it's against the law, it's against the board member's oath under KRS 160.170 for a school board member to influence in any way the hiring or appointment of district employees except the hiring of the superintendent of schools and the school board attorney. Isn't that correct?
That's correct.
So the only two people the board hires is the board attorney and the superintendent. Correct?
That's correct.
And you know that.
Yes, I do.
And you knew that when you became superintendent.
I say I read it when I became superintendent, yes.
Yeah. I'm sure you had, in your course of studies to become a superintendent, you had to become familiar with school laws because you were the professional advisor to the Board of Education. Is that correct?
That is correct.
And in fact, you had a college degree, a master's degree, correct?
Correct.
Including special training in being a school superintendent. Board members aren't required to have any more than a high school education, are they?
Or a GED, that's correct.
Or a GED. Your contract, the contract that you've discussed, that was entered into in 2005 and again in 2009, the contract provision essentially said, quote, in the event that a contract is terminated, non-renewed, or not renegotiated, Mark Blackburn shall be assigned to his previous or comparable position at the Martin County Board of Education Central Office. Is that correct?
That's correct.
And at the time, isn't it true that you knew that the Board of Education had no legal authority to place you in an administrative position in Martin County Schools?
Objection. Judge calls for a legal conclusion. He's not an attorney.
He's a professional advisor to the board and a party to this contract on which he says he relied.
Overruled.
You were aware of that, weren't you?
Of what?
That the Board of Education had no authority to appoint anyone or put anyone, including you, in an administrative position in the school system.
I will say that I knew they didn't have the authority, correct.
Okay. And if under the statute that I quoted, 161 or 160, 170, you knew that under the oath that board members are required to take the statutory oath, that board members are not permitted in any way to influence the hiring or appointment of district employees except the superintendent and the board attorney. Isn't that correct?
I know that's in the law.
Yeah. So that if the only way to fulfill the obligations of a contract that you entered into, knowing that the board didn't have the authority to place you in that position, would require the board members to violate Kentucky law and their own oath and influence or try to coerce the new superintendent into putting you into that position, into an administrative position in central office. Isn't that true?
No, it is not.
Well, how would they do it?
How would who do it?
Well, how if you knew the board didn't have the legal authority to put you in the position or to perform the contract that you signed, if you knew that, then the only way that you could be put into an administrative position would be a superintendent who followed you would have to appoint you or place you into an administrative position. Isn't that correct?
The superintendent does the appointment.
That's right. Well, in order then for the board to, for a board, a legal public body, elected by taxpayers here in Martin County, in order for the board to comply with this contract, it would have to illegally try to influence the new superintendent, either in negotiations to get him a job or after he got the position, they'd have to do something to try to influence him to carry out the terms of this contract to appoint you to a central office administrative position. True?
False. I wasn't determining to dictate to the board anything that they had to do.
I didn't say you did.
Well,
If the board didn't have the authority to do it, they'd have to try to convince the superintendent, the new superintendent, to do it. Isn't that true?
Not necessarily.
No. He could just do it on his own?
That's correct.
But at the time, if he chose as superintendent under another statute, KRS 16370, only the superintendent is vested with the responsibility for hiring and dismissal of all personnel in the district. Correct?
That's correct.
Well, all I'm saying is this, and you've answered it twice, and it is that at the time you entered into this contract, you knew as one of the parties that the board didn't have the legal ability to perform that clause. Isn't that correct?
They may not have had the legal ability to do that clause, but they do set compensation.
They set compensation.
Correct.
Well, there's nothing here that says that you get to, that you, after the contract is over, that you're entitled to a certain level of compensation for whatever position a new superintendent may put you in. Isn't that true?
That's correct.
When after your term as superintendent was over, and Mr. Meadows, Steve Meadows, was hired as superintendent, did you meet with him?
Yes, I did.
Did Mr. Meadows tell you that he didn't intend to appoint you to a central office administrative position?
No, he gave me a phone call.
Well, what did he tell you in the phone call?
To clean my stuff out of the central office.
Did he ever suggest to you orally and or in writing that you apply for one or two of the vacant principal's positions that were open in Martin County school system?
He suggested it, but by then it was too late.
It was not, in fact, too late to apply for the principalship of Warfield Elementary, was it?
It was not too late, but that's not a comparable position.
It's not a comparable position, but when you left the position of principal at that same school some 8 years before, or 9 years before, I guess, it was paying more than $70,000 a year, wasn't it?
I'm not sure of the pay scale.
Well, is that what you said?
I said
that as
$70,000.
principal, you were making about $70,000.
That's what I said.
Mm-hmm. and this is 9 years later, and a principal's position is an administrative position, isn't it?
It is.
But you didn't want to apply for that job because it wasn't, in your opinion, comparable.
It's not comparable, and there's no control of that position. The site-based controls that position.
If you had applied for that position, you could have been hired by site-based counsel, couldn't you?
Possibly.
Okay. But you didn't give yourself the opportunity to do that because you didn't want to be a school principal.
No, it wasn't.
Right?
No, it wasn't that. They already had their mind made up.
Well, they hadn't hired anybody, had they?
They already had their mind made up.
They hadn't hired anybody, had
They
they?
already had their mind made up.
Had they hired somebody or not? Yes
No,
or
not to my recollection.
In fact, as of July 1st, the posting period hadn't expired, has it? The time, as superintendent, isn't it true that all jobs for certified positions, whether it's a school teaching position or an administrative position, including a principal's job that becomes vacant, Kentucky law requires that the position be posted on the KDE website, board office, and other places so that people know that a vacancy exists so that people can apply for it.
That's correct.
And isn't it true that that job posting is required to be left open for 30 days?
That's correct.
And the 30 days had not yet expired as of July 1st, 2013 for the vacant principal's position at Warfield Elementary School, had it?
I don't think so.
May I have just a second, Your Honor? No further questions.
Redirect.
Mr. Blackburn,
Yes.
Mr. Schmitt's asked you about being a principal. That wasn't the position you were guaranteed under the contract, was it?
No, it was not.
And you relied on the fact when you signed these contracts that you would go back to the central office, correct?
Correct.
Now, is there anything that would prohibit the Board of Education from paying you as an administrator, no matter what position you hold?
No, there is not.
They can pay you as an administrator even if you're a teacher.
That's correct.
And comparable pay equals a comparable position, correct?
Correct.
Objection.
And
Basis of the
you were-
objection. Just a minute. Basis of the objection.
Well, the basis, I'll wait till cross-examination.
Okay.
Sorry, Your Honor, I withdraw the objection.
Okay.
If you would, Ms. Blackburn, look at Exhibit 6 again. I think when I asked you about the differential in pay, once you get your doctorate at the end of this year for next year, what will be the difference in pay starting next year between an administrator and a teacher?
$30,946.
Just want to clarify that too. That's all the questions I have, Judge.
Mr. Blackburn, as a longtime teacher, school principal, and superintendent, you know that under Kentucky law and the Kentucky Department of Administrative Regulations, that each district is required to have a single salary schedule. Isn't that true?
That's correct.
And everybody who is on that salary, every employee is accounted for on the salary schedule. In terms of teachers, as you've indicated on the exhibit 5, a teacher with a 185-day contract who has had so many years' experience falls into a group, and there are various groups, and teachers in different groups fall into various boxes on the salary schedule.
That's correct.
And as a public institution, the school board, the school district, has to treat all employees in the same classification exactly alike. Isn't that true?
I guess that depends upon the board.
It depends on the board.
It does.
In order to have allowed you to be a school teacher with a 185-day contract and paid as an administrator with a 240-day contract, plus a stipend that other teachers didn't get, the board would have had to have made a salary schedule that was for you that was different than for every other employee in the district. Isn't that true?
If that was the route they was going to go, yes.
Yep. And that's the route they would have had to go in order to do what you say is pay you anyway.
That's the route they need to go.
That's the route you think they needed to go.
That's correct.
It is true, and you know as a longtime school superintendent, that a Board of Education cannot legally pay for services that are not rendered. Isn't that true?
That is correct.
And in order to have paid you under this contract that you knew the board was legally could not enforce or perform, the board would have to pay you as a 185-day teacher the same salary plus stipend as a 240-day central office administrator. Isn't that correct?
That's not correct. I was willing to work the 240 days.
You were what?
Willing to work the 240
I
days.
understand.
Right.
But if you were placed as a teacher and not an administrator, you had a 185-day contract.
That's correct.
And if you were paid for 240 days on a 185-day contract, plus you got a stipend, you would have been paid for services that you were not rendering. Isn't that true?
If they were basing on the days, correct.
And a school district can't pay for services that are not rendered. Isn't
That's
that
correct.
true?
That's correct.
No further questions.
Mr. Blackburn, did the board sign that contract?
Yes, they did.
They had legal counsel at the time they signed that contract?
Yes, they did.
Thank you. Nothing further.
Nothing further.
All right, you may step down. Next witness.
Judge? Respondent with rest.
Okay. Evidence for the plaintiff.
May I have 5 minutes?
Yeah, we'll take a 5-minute recess.
All rise.
Includes the proof.
Yes, sir.
Okay. Let me ask you gentlemen a question. Mr. Blackburn testified that he has tenure as a teacher. Is there a separate tenure process or separate tenure situation for administrators?
Judge, the people call it administrative tenure. If you're in an administrative position for 3 years, you have certain procedural rights if you're demoted. You can appeal the demotion to the board. The board makes a decision. You don't actually have tenure.
As
but
we would.
after 3 years, you at least, up to 3 years, if they demote you, you're done. After 3 years,
There's some due process
there's a
involved,
due process.
but
issue.
not an absolute, well, I
No,
don't
sir.
guess tenure is an absolute right, but it's a fairly strong position. Okay. Okay.
Yes, sir.
Okay.
You would appeal your demotion to the board. The board does what they're going to do.
Okay. All right.
You
Thank
could appeal that to court, but like all administrative matters, very difficult for the court to overturn
I
administrative.
understand.
Judge, could we give you a very brief argument?
Yeah, let me ask one question. You want to take Mr. Priest's deposition?
Well, I don't think so, Judge, based on what we've
Okay,
not
it's
heard
either
today.
yes or no. I need to know. Because if you do, we'll wait a few days. If not, I'll go ahead and start working on this decision. Okay. All right. Argument.
I'll let Mr. Schmitt go first. I
Okay.
suppose, Judge.
Your Honor, the public schools in Kentucky are a product of the Kentucky Constitution. And over the years, the General Assembly has amassed a large section, a large body of law applicable to schools. Many of these laws are maybe dubious value and difficult to discern. But one thing is clear in this group of statutes is that over time, the Kentucky General Assembly has limited the power of boards of education to do anything other than control the budget, be responsible for school buildings, and hiring the superintendent, and if it chooses, a board attorney. Back before CARA, in time, in the 60s, 70s, 80s, boards of education hired school teachers, and they fired school teachers. But as time has gone by, it has been determined that it's in the public interest for professional educators to hire teachers, to discipline teachers, and to place people in administrative positions based upon the professional judgment of the person who is the school administrator at the time. And at least since 1990, when the Kentucky Education Reform Act came into being, school boards have had nothing whatsoever to do with hiring people or placing anybody into an administrative position. In this case, when Mr. Blackburn got this contract, and obviously the contract he felt was beneficial to him, he was the professional advisor to the school board. He was, after he became interim superintendent in January of 2005, the superintendent. He applied for it, obviously got the job. And he negotiated, or had put into a contract, a provision that said that if his contract was ever over, he'd go back to an administrative position at a $77,000 or so a year job that he'd held for 5 or 6 months before he ever took the superintendent's job. And he knew, as he admitted, that the Board of Education had no legal authority to ever enforce this provision. It was a contract term that they may or may not have known, but he knew for a fact was against public policy and contrary to the laws of the state of Kentucky. And now he's here in court seeking redress of a manufactured grievance where he says, they signed this contract with me, Judge. I'm entitled to this money because I relied on it. I knew it wasn't worth 2 cents. I knew that they couldn't carry out the terms of this agreement. And the only way they could would be to violate their oath under KRS 161 370. That's not the statute. Under KRS 160-170, because they're not able to, they're legally prohibited from influencing any employment decision. Anything that was done was illegal. You know, I can understand how it can be said sometimes, well, you know, you made a deal and you made a deal. The difference is this. Whoever it was, whatever they know, we don't know who those board members were in 2005. We know who some of them were in 2009. But we know one thing for sure. I don't know what they knew about the law. You only have to have a high school education. Dr. Wells obviously was a medical doctor. How much law he knew, I don't know, and I don't know what John Triplett knew. But I do know one thing, that when board members meet in a meeting, they're not acting for themselves personally. They may have been Mark's buddies. They may have been his friends. They may have thought he was a rising star in the educational field. But when they vote to sign a contract, or when they act for Martin County. They act as only in session as a public body for the interest of every school kid, of every taxpayer in this county. And so their actions go beyond what they do as individuals. They acted as a public entity and are required to essentially obey the law. They can't act outside their own powers. And here, not only were they acting outside their own power to perform, but Mr. Blackburn knew it himself. So they entered into an agreement, knowing the law would not permit such a contract to be legally performed, and Mr. Blackburn says, I knew it, but they signed it, so they ought to be bound by it anyway. I think that contract is against public policy because it violates every statute that involving the superintendent's duties and the school board's duties. And therefore, it was null and void. We think the law is that every contract that's entered into in this state, especially between public bodies and public employees. Remember, the superintendent is not an employee of this board. He's a public officer. Under the law, he's a state officer. He has to take the constitutional oath. He's an officer. So he knows that he's supposed to be there protecting the public and basically signing agreements that are valid. But he didn't. He chose not to do it, even though he says he knew it. We don't think that contract is enforceable and it shouldn't be performed. Moreover, Mr. Blackburn has acknowledged that when he became superintendent, he was no longer a school administrator because the statute specifically provides that the superintendent can only perform the duties of a superintendent. And he knows, and he's also admitted that in effect, when he took the superintendent's position, he resigned as a de facto resignation, left an administrative position with the school district, so that when his term as superintendent ends, he's not a school administrator anymore. He'd have to be put in that position by a superintendent or someone else. And if he was, he'd be subject to demotion. So what does he legally have? He has a contract that we contend was illegal and to start with, and that he knew it. That if there is such a thing as unclean hands, in peri delicto, this is a good example of it. And number two, that he can't get into this position. So he says, well, you know, they ought to pay me anyway. Although he knows that he can't pay a teacher an administrative salary because when he doesn't perform the duties, because a school district in Kentucky cannot pay for services that are not rendered. And last, if he had taken the position, if Mr. Meadows, the new superintendent, had chosen to put him in an administrative position, it could not legally be for the purpose of fulfilling a contract which on its face is in violation of Kentucky law. But notwithstanding that, under KRS 161.765, he was subject to demotion. And so no one knows at this point, even assuming he had a claim, how long he would have worked, what he would have been entitled to, because as school resources shrink, positions are eliminated. We don't know how he would have performed his work, how he would have gotten along with the new superintendent. But one would know why a new superintendent wouldn't want to work in the same office with someone who'd held a job for 8 years and with whom the board was dissatisfied, because one could assume the working relationship would probably not be very wholesome for anybody. But in any event, he had no guarantee of anything once he was ever in an administrative position in the first place. So, Your Honor, that's essentially our position, and I'll leave it to Defendant's counsel.
Judge, one thing Mr. Schmitt keeps ignoring, the Board of Education's legal counsel, their lawyer told him the contract was okay. They didn't get a legal opinion from Mr. Blackburn. They got a legal opinion from their lawyers. They sign a contract, they sign it 4 years again, they change terms. If you look at the second contract, there's specific terms changed. They don't change that term. Now, having signed this contract, they want to say, Kings, we don't owe the money. They signed the contract. They said what they were going to do. Now, Your Honor has already indicated there can't be specific performance, but they could be ordered to pay the superintendent the difference. That's what they contracted to do, to pay him what he was being paid before he became superintendent. And case law in this state provides that if you contract to do something you can't do, you're still liable for any damages that flow from your breach. And they most certainly breached this contract. Judge, there are numerous cases where a demotion of an administrator has been done improperly, and boards of education have been ordered to pay that person even though they've been reassigned as a classroom teacher. Mr. Schmitt says that's illegal. Well, courts all over this Commonwealth have then ordered illegal actions because they have ordered boards of educations to do that. The other issue here is, on a demotion, in order to lower someone's pay, you have to lower their duties. Mr. Blackburn's been assigned as a classroom teacher. We believe he's entitled to be paid as an administrator, which the Board of Education most certainly does have the power to do. They can't demote him. You can't get demoted below a classroom teacher. You can't take duties away from him. His duties as a classroom teacher are the minimum. Administrators have more duties. They haven't assigned him more duties. So how can they take his pay away? That's why his salary is until he retires. That's what the Board of Education agreed to do. Now they don't want to do it. They're mad at him. They don't like him. Whatever the reason is, they're still liable for the breach of this contract. That's the law of this state. It's been the law of this state since 1922 in Nolan versus Highball, 196 Kentucky 563. Judge 196 Kentucky 563. The equities in this case are that the Board of Education agreed to do something. They agreed to do something based upon legal counsel. Now they don't want to do it. He's not the lawyer to the board. Yes, he negotiated. You heard his testimony. It was important to him. Judge, he took a $13,000 pay increase, and now it's costing him much more than that. That's why he wanted that contract term in there, that he would be protected. He was protecting his family. Most of us, hopefully, are on an upward incline in regard to our salary. His dropped dramatically. The Board of Education most certainly has the right to pay him, but they don't want to pay him. Judge, the equities are with my client. Their lawyer, not Mr. Schmitt, their prior lawyer, on 2 occasions saw absolutely no problem with his contract term. None. Nada. He had no problem recommending to the Board of Education that they accept 2 contracts, not 1, 2, which agreed to provide Mr. Blackburn an administrator's salary if they removed him as superintendent. That's what they contracted to do. That's what they should be ordered to do. And, Your Honor, we thank you for your time today.
Let me ask you a question. Your paragraph 16
Yes, sir.
about assignment to a previous or comparable position, what is the length of time of that assignment that you believe is expressed in the contract?
Judge, had they put him back, it would be as long as until the superintendent wanted to remove him. But again, they didn't do that.
Until the superintendent wanted to remove
If
him.
Mr. Meadows had put him in an administrative position,
Yeah.
and at the end of this year wanted to demote him from that position, he could have done that. But they didn't do that. They put him in a teacher's position,
Okay.
and they could no longer take away any duties from him. That is why we believe until he retires, his earliest retirement date, Judge, is the time that his damages flow till they would end when he can retire.
Mr. Schmitt, do you agree with that proposition that at the end of 1 year, the new superintendent could demote the defendant from a previous or comparable central office position?
The superintendent could demote Mr. Black, assuming the superintendent placed him in that position. The superintendent could demote him at any time, but since he would be placed in the position after, in a time period less than 90 days before the start of school, he would have to be paid that same amount, even though he wasn't performing the duties for the 13-14 school year. Yes, he could be demoted. If he was in a position, he could have been demoted within a year. That's correct.
Okay. All right, gentlemen, thank you much. I'll get you a decision out as soon as I can.
Thank you again for continuing this due to the weather.
It was a little dicey yesterday. I made it, but I don't know that I'd expect many others to make it.
All rise.